Hey everybody, welcome to the U.S. Civil War in Excruciating Detail podcast. I'm your host, Will, someone with an interest in the Civil War but not enough to do the research. So joining me is someone who is willing to do the research, my buddy Steve.
Hey, I'm Steve. I am, I guess at this point I'm an amateur historian, but I'm not an actual historian. I don't even actually have a college degree. But what I am is autistic, which means when I find something that really captures my interest, I research it into oblivion, and just keep riding that high until I get bored and move on to the next thing. And the U.S. Civil War and the period surrounding it has been one of the topics that has held my attention longer than most. And yeah, so it's been fun, and all the stuff that I've learned over the years and things like that, you know, it was always just kind of for me, and then for the occasional rant with friends whenever somebody made the mistake of asking me a question and they ended up getting an answer they were not ready for or expecting. But now I get to share it with all of you.
Incidentally, that was the impetus for the podcast. I was on the receiving end of a number of those aforementioned rants, and I figured, you know, if I recorded these,
Yeah,
I could force other people to listen to them.
That's fair. Also, if it looks like we've been crying,
Yeah, we're at a little bit of a giggly mood.
we had a Murphy's Law moment as we went to start trying to shoot this episode, and something happened right before this final take that if we ever release a gag reel, you guys will see.
Oh, it's going at the end of this episode.
Oh, it's going at the end.
It's going at the end of the episode for sure.
So you got to watch the whole way through to see that.
Yeah, no timestamp in the description, everybody.
For those of you that are listening, you're going to have to go to YouTube and watch it to see. But if you listen first and then you go to YouTube, you know,
That doubles our view count, so please.
Yeah, 100%. But suffice it to say, you can't script something like that. And yeah, we were both laughing to tears. And so if we look a little flustered and we're a little giggly and barely holding it together,
Even more than usual.
that is exactly why. It's been a fucking nightmare trying to get this one going.
Yeah. Yeah.
Anyway.
Incidentally, hopefully we have sorted out the lighting issues. I know I said that last week, and then when the editing process started, I was like, we did not solve the lighting issues. So with all of the disclaimers, caveats, and as the late Paul Harrell would have said, yeah, buts out of the way, what are we talking about this week?
All right, so we're continuing on with our theme of discussing the events in American history prior to the Civil War that directly influenced it and started closing up those sides of the boxes that made war inevitable. Because, like I said in a previous episode, at no point was war truly inevitable until it was. And so in the last couple of episodes, we discussed the economy of the United States as a whole. And in this episode, we are going to discuss the legislative protections for slavery in the pre-war United States. And it's, if the timeline feels like we're jumping around just a little bit, it's because I felt it was most important to start with the actual Constitution of the United States, and discuss the protections for slavery that are in the Constitution, and then move on to the actual pieces of legislation that were passed by the Congress after the Constitution was ratified. Oh, excuse me.
So we're kind of going by topic more than
strict time, more than strict timeline, right? But in general, it is going to be in order. It's just So, if you ever have the notion to actually sit down and read the United States Constitution as it's actually written, first of all, you have quite a bit of intestinal fortitude, because it's a dry document, as are most legal documents. But if you read through, you'll notice that the word slave or slavery or enslaved person never appears anywhere. And that had a lot to do with the fact that while the Southern delegates to the Constitutional Convention in 1787 wanted to explicitly protect slavery within the Constitution, the Northern delegates did not. And it's important to note that at the time the Constitution was being drafted, there were a significant number of what would become northern states that had slaves, where slavery was legal.
So were a lot of the founding fathers at this time like abolitionists, or was it just something that they didn't feel like it needed to be expressly talked about in the document?
More so that. I'm sure some of them were explicitly abolitionist, didn't approve of slavery, didn't want it protected by the Constitution in any way, shape, or form. But at the same time, even the ones that were anti-slavery and, didn't want that institution at all, it's important to remember they were still extraordinarily racist by modern standards. So it was really more a matter of compromising, because you got to remember, by 1787, it was already apparent that the Articles of Confederation had failed completely. I can't remember who said it, but one of the significant figures at the time was quoted as saying that the Articles of Confederation are a chain of sand. It had very little substance. There was no way for the federal government to sustain itself outside of the whim of the states. And, when you put any entity in a position where it has to choose between being selfish or being altruistic, more often than not, they're going to choose the selfish route. I'm going to secure me and mine, and then I'll think about helping you. And all the other states were in direct competition with each other, economically. And so, under the Articles of Confederation, every state wanted to make their own position as secure as possible. And the federal government, or I guess it would be the national government, really was like a distant 18th in terms of the list of priorities. So, by 1787, this was it was accepted by basically everybody that this system was not working, and we needed something else. And so that's what prompted the Constitutional Convention in Philadelphia. So there was very much this idea of, I want to protect my own interests, but also I, as my state, don't want to go this alone. I don't want to be my own country, So they wanted to make this work. Everybody in the convention wanted to make this work. It's just there were certain issues that they had a really hard time compromising on, and one of those was the issue of slavery, not its practice, but how are we going to treat slaves? And that kind of brings us to one of the first things that I want to talk about, which would be the 3/5 compromise. Now, most everybody remembers the 3/5 compromise from high school history class, but what not everybody might know is that it's actually part of the Constitution. It was not a piece of legislation passed by the Congress. This was written into the Constitution. And the reason it's there is because when it came to determine how states would be represented within the legislature, the southern states wanted their slaves. They wanted their slave population to count towards their state population for the purposes of representation within the government. And the North, who by and large either had already abolished slavery or had begun passing legislation for the gradual emancipation of slaves within its borders, were like, well, hang on a minute. That's going to mean that the South gets more representation than us without the people that are being counted for that being able to participate within the system. You know, the North was basically like, you cannot have your cake and eat it too. You cannot say that these people are property and then say that for the sake of the census and determining representation, they are people. You can't do that.
So the 3/5 compromise was written into the Constitution as a result of all of this kind of back and forth.
Mm-hmm.
If the word slave and enslaved person, et cetera, doesn't appear in the Constitution, how is it phrased?
So I'm going to read the verbatim article, the verbatim clause that is the 3/5 compromise. This is Article 1, Section 2, Clause 3 of the Constitution. You can go read it yourself. It's exactly as I'm going to say it. It says, representatives and direct taxes shall be apportioned among the several states which may be included within this union, according to their respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years and excluding Indians not taxed, 3/5 of all other persons. So the part where it says including those bound to service for a term of years is directly referring to the enslaved peoples in the South. Because if you were born a slave or if you were purchased as a slave, you were bound to a term of service for the number of years that were however long you were going to live. That was how the system was set up. If you were born a slave or you were bought as a slave, you were a slave until the day you die.
Oh, I would have thought that referred to like indentured servants or something like that.
It did too.
Maybe that's on purpose, but the phrasing makes it sound as though that's excluding.
It is meant to be obscure. It is meant to be opaque. That's the word I was looking for. It's not meant to be explicit. It's meant to be interpreted. Because again, the North didn't want to put into the Constitution that the country as a whole directly supported the practice of slavery. Even though a decent chunk of it did. Well, maybe not, about half. So yeah, still a decent chunk. And you know, like I mentioned a couple of episodes ago, you know, even slave holders like Thomas Jefferson and George Washington too, though George Washington wasn't one of the architects, he was just the president of the Constitutional Convention. But, you know, even somebody like Thomas Jefferson recognized that the sentiment of the developed world was changing, in that slavery, the practice of slavery, was becoming less and less acceptable amongst European powers. And for a fledgling nation who is seeking legitimacy, even Thomas Jefferson recognized that eventually the practice of slavery was going to become a blemish on the United States. And so, and he was a Virginian. And, you know, I'm not saying that to try and paint this picture of Thomas Jefferson as this forward-thinking, progressive, reluctant slave owner. He was not a reluctant slave owner. You know, he was fine with it.
Yeah, I think you'd be very hard-pressed to find a reluctant slave owner, considering what it takes to acquire them.
So I'm not saying all of this to try and paint the picture that Thomas Jefferson was this, you know, benevolent, reluctant slave owner. He wasn't. He was an unabashed slave owner. He had no issues with the fact that he owned slaves. But I'm saying this to illustrate the point that even certain slave-owning people in the South, of which Thomas Jefferson was one, could see the political
writing on the wall.
Yeah, could see the political writing on the wall, even in 1787. So that's why everything that in the Constitution that discusses slavery in any kind of capacity, which admittedly there's not a lot, is worded in a very roundabout way on purpose. So basically, what the 3/5 compromise says is that for every one whole person, you will count 3 slaves as another person. So I said that a little backwards. For every 3 slaves, it will count as one person for the purposes of representation. And it was still kind of unfair, because it did mean that the southern states were going to have marginally more representation within the legislature than the northern states that didn't have slaves would. But again, the idea was we need a document to govern, or to lay out our government. And so, you know, we can address it later.
Yeah, I think this would be a good time to point out that when you're discussing legislation involving the owning of humans by other humans, the idea that anything's going to be fair is already out of the window.
Exactly. Yeah. The next spot, or another spot in the Constitution I want to highlight, that many people will have heard of the legislation that goes by the same name, but maybe not everybody knows is actually in the Constitution, is the Fugitive Slave Clause. Most everybody's heard of the Fugitive Slave Law of 1850, which we'll talk about. But there's actually a clause in the Constitution directly pertaining to fugitive slaves. But again, they don't use the word slave. And again, I'm going to read it verbatim so that there's no question. It's Article 4, Section 2, Clause 3. It reads, "No person held to service or labor in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due." Basically, what that means is, if you're a slave and you are and you escape into a state or territory where slavery is not legal, that does not mean you're free. What that means is if you're captured, the government has a duty to return you to the person that's claiming you. And the clause of the Constitution just before this one directly supports this. It's Article 4, Section 2, Clause 2, and it's called the Extradition Clause. Now the Extradition Clause isn't meant only for slaves. It's meant for criminals of any kind. But it's important to remember, if you were a slave and you escaped, that was against the law. So you would fall under this. And it reads, a person charged in any state with treason, felony, or other crime, who shall flee from justice and be found in another state, shall on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. Which, in layman's terms, means if you are a criminal of any kind, and you commit a crime in one state, and then flee to another state, if the governing body of the state from which you fled says to the other state, you need to capture this person and send them back to us, that other state has an obligation to do so. This covers all manner of criminal, but pertinent to this conversation, it also governs fugitive slaves. And so these three clauses of the Constitution are the most direct in terms of specifically protecting the practice of slavery. And they're not so much protecting, I guess, where it's indentured servitude will be legal for X number of years, but they are provisions supporting it. And they provide avenues for slaveholding states to gain more representation, which means it's easier for them to pass pro-slavery legislation, number one. Number two, they also provide the mechanisms for preserving the practice and returning escaped slaves back into bondage.
Yeah, they're not the kind of things that explicitly that explicitly keep it legal, but they're the kinds of things that you need to have in place if it's going to be legal. Right,
exactly. And so that brings me into the legislation that explicitly protects slavery. The very first one was the Fugitive Slave Act of 1793. This law gave the judicial branch it gave the judicial branch at both federal and state levels the legal mechanisms needed to return captured slaves to their owners under the Fugitive Slave Clause. It used really broad definitions of proof that slave catchers, slave holders, or their representatives, read attorneys, would need to provide in order to claim a person as a slave. And again, I understand it's dry, but I want to read what the document itself actually says with regards to this. It says, quote, per Section 3 of the law, in any state, county, or town wherein such seizure or arrest shall be made, and upon proof to the satisfaction of such judge or magistrate, either by oral testimony or affidavit taken before and certified by a magistrate of any such state or territory, that the person so seized or arrested doth, under the laws of the state or territory from which he or she fled, owe service or labor to the person claiming him or her, it shall be the duty of such judge or magistrate to give a certificate thereof thereof to such claimant, his agent, or attorney, which shall be sufficient warrant for removing the said fugitive from labor to the state or territory from which he or she fled. So that it's really flowery language. It's clearly legalese, but I think in spite of that, it's also rather self-evident. It doesn't take a whole lot of additional explanation, because again, this isn't like a this isn't in the Constitution or anything, so they can be a little more direct. And even though they still don't directly use the word slave, they use the phrase fugitive from labor.
Right, or someone owing labor. Right.
It's not very it's not very subtle. The reason that the Fugitive Slave Act of 1793 was brought up at all was because of a man named John Davis. So John Davis was a freedman. He was African American, but he was free, living in Pennsylvania in the early 1790s. And in the early 1790s, he was kidnapped from Pennsylvania by Virginian slave catchers and taken to Virginia, where he was claimed as a slave prior to the Fugitive Slave Act of 1793. So this would have been anywhere from 1790 to 1792. Understandably, this kidnapping, when news got out, caused a massive outcry from Northern abolitionists. Both not just within Congress, but without as well. The Northern abolitionist public was livid that this could happen to a free person living in a state where slavery was on its way out. At the time, it's important to note, Pennsylvania was not a slave-free state. It still had slaves within it, but it had passed legislation for their gradual emancipation. I think I talked about in a previous episode, George Washington and his slaves. They had to cycle them through the presidential household in Philadelphia because Pennsylvania had passed legislation that said that any slaves residing within Pennsylvania would be freed after a certain number of months by default. And so John Davis was a freedman living in a state that was gradually emancipating its slaves. It was getting rid of the practice of slavery within its borders. And here come these slave catchers from Virginia who just see a black man on the street and go, him, and grab him, Shanghai him to Virginia, and somebody in Virginia said, oh yeah, no, that's my slave, and he escaped, and he's mine. Caused a massive outcry from Northern abolitionists. And so one of the ways that the federal government sought to try and remedy this travesty of justice, miscarriage of justice, I guess, if you want to say it that way, was to enact the Fugitive Slave Act of 1793, because prior to that, there was no explicit definition of what somebody needed to do to claim somebody as a slave. And so they're like, oh, this'll fix the problem.
Right. So a slave owner could be like, he owes me labor because he's black, that's why.
Right. And it should come as a surprise to literally nobody that the Fugitive Slave Act of 1793 basically failed in every aspect to resolve this controversy. The slave catchers that kidnapped John Davis were never extradited to Virginia or to Pennsylvania to face justice for the kidnapping. And poor John Davis lived out the rest of his days as a slave in Virginia. He was never freed, and he was never returned to freedom that he was unjustly taken from. So the Fugitive Slave Act of 1793 basically failed at everything it was trying to achieve. And as far as I could tell, that particular controversy ended the way so many of them do. People just kind of forgot about it and moved on.
Something else happens to make the papers, and
right. And then poor John Davis is just left to rot on a Virginian plantation. It's very similar to what was that book, 12 Years a Slave. They made a movie about it not too long ago, and as far as I know, that was actually based on another true story of a freedman in the North who was captured by slavers.
Incidentally, there's some great music in that movie.
I haven't seen it yet, but I kind of want to. It's just I got to have the mental and emotional bandwidth to watch it.
It's not an easy film.
No, from the clips I've seen, it will be a very difficult film to get through when I do eventually watch it, and the acting in it is phenomenal. And it's an important story to tell. All of this is a part of our history that it's critically important to acknowledge happened, and to not try and bury our heads in the sand and say, no, this didn't happen. No, we never had, people who proudly owned other human beings and treated them as property.
For lack of a more subtle term, attempt to whitewash it.
Yeah. It's critically important that, that we not do that, and that we never forget these things. But anyway, before I go off on too much of a tangent, because we still got quite a bit of legislation to get through. So the next significant thing, the next significant act of legislation surrounding the issue of slavery in the United States was the Missouri Compromise of 1820. Again, it's another one of those big ticket items that most of us are going to remember at least the name of from high school history. And it was significant at the time because it restricted where slavery as a practice could expand to. It allowed Missouri to enter the Union as a slave state, and it allowed Maine to enter the Union as a free state, and it restricted the practice of slavery anywhere in the Louisiana Territory only to lands below the 3630 line, which we would colloquially know as the Mason-Dixon line. It basically established the precedent of states being added to the Union in pairs, one slave, one free. And it placated the Northern abolitionists by saying, hey, look, we get it. We don't want to be a country where slavery can just go wherever it wants to. So how about this? We'll admit states in pairs. One will come in as a slave state, one will come in as a free state, so that ostensibly neither philosophy will gain more representation than the other. And we will only allow slavery in the Louisiana Territory, Louisiana Purchase territory, below this specific line on a map. Anything north of that, free by default. Anything south of that, slave by default. End of argument. Everybody's happy.
Was there any sort of gamesmanship? Like, if I was a Southern politician at this time, I'd be like, okay, so here's this Louisiana territory, and naturally we might split it up into, 3 states. But if we split it up into 8 states...
I don't know. I don't know if anybody went on the record about that, but I'm sure somebody thought of it.
I guess the better play would be, rather than having this territory that would naturally be split into 3 states, we'll make it one really big state.
Deep breaths, buddy. Deep breaths.
We'll make it one really big state so that the North only gets one additional state.
I don't know. Like I said, I'm sure somebody thought of it. You know, these weren't stupid people. These weren't unclever people. You know, they were people just the same as you and I. So if you can think of that, I'm dead certain people at the time did too. I just don't remember having ever seen any direct evidence of explicit gamemanship like that. Though I'm sure if you really dig into the legislation, even specifically the stuff that didn't get passed into law, or that didn't get signed into law, excuse me, I'm sure you would find several examples of that. We just don't talk about them, or we don't even find them easily on a search because they didn't become law.
Yeah, or they didn't have that big of an effect if they did manage to get some sort of little political wrangling in place.
Right, exactly.
Like Texas is real big.
Right. But Texas also wasn't part of the Louisiana Purchase territory.
Yeah.
So the Missouri Compromise basically did that. You know, the intent behind it was to prevent any one section from gaining significant power and influence over the other. We're going to talk about it a little bit down the line, but when the Kansas-Nebraska Act of 1854 was passed, it effectively nullified the Missouri Compromise, and that was a major point of contention with the North, because they're like, hey, you know, we had this agreement, 34 years ago. We laid this out. You can't just undo it. And they were basically like, bet. But anyway, so by 1836, Northern abolitionists in Congress were getting much louder, and the House got sick of it. The Southern Democrats, which controlled Congress at the time, were sick and tired of having to field all of these petitions and speeches against the practice of slavery. And so what they did was they passed the House Gag Rule of 1836. And it was passed as part of the Pinckney resolutions, which I'm not going to go into. But suffice it to say, they were called such, and this was part of them because they were authored by a man named Henry L. Pinckney of South Carolina. Not really going to go into much of who he was, because it doesn't really matter. All you really need to know is that he was one of South Carolina's representatives, and this was basically his idea. It stated that in addition to the gag order, that the Pinckney resolutions did, that Congress had no constitutional authority to interfere with the practice of slavery in the states, and that Congress ought not to interfere with slavery in the District of Columbia, the capital.
Can you say that part again? It said cannot and ought not?
Yeah, Congress had no constitutional authority to interfere with slavery in the states, and Congress ought not, verbatim, ought not to interfere with slavery in the District of Columbia. So,
is there significance in the legalese of saying ought not? Or is it just a fluke of how they wrote it?
My personal take is that it's a rather significant legalese, because it's basically saying Congress technically can in the Federal District of Columbia, because we are the governing body of sorts of the Federal District of Columbia, but like we really shouldn't, it's not a state, but we really shouldn't like touch it.
Right. My question is how much winking and nudging is implied by that phraseology?
I don't know. I think I just did a lot of it. So,
okay. So suffices to say, yes, that phrase was chosen carefully.
Yes. But the getting back to it, the House gag rule forbade the explicit discussion of slavery on the House floor. Like, no more talking about any issues surrounding slavery within the House. It also forbade raising or considering any legislation dealing with slavery on the House floor. So basically, this gag order not only said you can't bring up any proposed bills that would be detrimental to the practice of slavery within the House. You can't even debate the issue of slavery within the House.
Even today, I can't picture something like that passing.
Yeah, it was crazy. The fact that like the House just passed a measure that forbade any discussion of it. And the reason that this was the reason that this was pushed was because at the time congressional procedure was that after the initial roll call had been done and any like previous minutes from the last session of Congress were read out, Congress would then read out any petitions that had been sent to Congress with sufficient number of signatures. The petitions would be read out on the floor, and then they would be assigned to a committee to evaluate whether or not that petition should be considered or disregarded. And so many of these coming in were from Northern abolitionists petitioning Congress to do something about the practice of slavery, that Southern Democrats were like, nope, we're not doing this anymore. We're not even going to consider talking about it.
If you ask me about it one more time, I will turn this car around.
Right, exactly. And the gag order lasted all the way until 1844. It was renewed every congressional cycle until 1844, when the Whigs took back full control of the House and had an unvetoable majority, or a filibuster-proof majority. And it was purely done because Southern Democrats didn't want the issue of slavery to be debated. Slavery was here, and it was here to stay, and nobody should be interfering with it ever, and so it shouldn't be discussed. It is a fact of nature, is how the Southern Democrats looked at it. It is a fundamental law of nature that slavery as an institution needs to exist, and so there's no reason to debate it because it's self-evident. Admittedly, I'm putting words in their mouth. I'm sure there are direct quotes from Southern Democrats in Congress that said basically exactly that, but I'm not quoting anybody directly. This was the general sentiment of Southern Democrats, was this is a law of nature. This is just default how it is. So why discuss it? There's no point. And the big problem with this was that it further divided Northern and Southern legislators along sectional lines. Northern legislators, in my opinion, very justifiably viewed this gag order as a violation, a constitutionally a violation of the constitutional right of American citizens to petition the government. And John Quincy Adams specifically, you guys will remember his name from, I've mentioned him a few times in the last few episodes. He specifically opposed the gag order, stating that it was a violation of the First Amendment.
Yeah, absolutely.
He said this is unconstitutional. That you can't just say that Congress is forbidden to read petitions from citizens that talk about slavery. That is a direct violation of the First Amendment, because the First Amendment, among its many guarantees of free speech and free press and free religion, also guarantees a citizen's right to petition the government.
Yeah, I think that's a First Amendment violation, kind of the highest order, because you're violating the rights of the people to have their opinions read by the Congress, and it's also preventing the Congress from discussing those opinions, even if they did hear them.
Exactly. The funny thing is that this gag order caused a Streisand effect in the North.
I'm not familiar with that phrase.
So, for the uninitiated, many years ago, there was a very unflattering picture of Barbra Streisand that appeared on the internet. And Streisand was very upset by the fact that this picture got published and actually sued whatever website had published this picture to try and force them to take it down. The end result was that when people found out that she was suing this website to get this picture stricken,
they went to find the picture.
They found the picture, downloaded it, and then posted it everywhere else until it was so ubiquitous that there was no way to pull it down at all. So way more people ended up hearing about it and seeing it than would have otherwise if Streisand had just let it ride. So that's kind of colloquially been referred to as the Streisand effect. The harder you try to remove something from public attention, the more attention it gets. And that's kind of what we saw happening amongst Northern abolitionists in the wake of the gag order when it went into effect in 1836 and until its repeal in 1844, was people who maybe didn't really care as much about the issue of slavery, but who cared very much about the First Amendment right to petition the government, started sending petitions to Congress to discuss the issue of slavery. So the gag order had the opposite effect, the opposite of the intended effect.
Yeah, right. Hey, Fred, did you hear about that gag order that they did in the House?
Yeah, exactly. And so, did it change anything? No, not really. It still took the better part of a decade for, the gag order to be repealed. But it was still a nice little middle finger to, the Southern Democrats who were, at the time, actively trying to take away half of the country's First Amendment right. The next big piece of legislation I want to talk about is the Compromise of 1850. So we've jumped ahead a little bit in time. We've gone from 1844-ish, 6 years down the line. And the Compromise of 1850 did a number of things. This was a really, really big piece of legislation. I'm a breeze through some bits of it and focus on others. But basically, it allowed slavery into the Utah and New Mexico territories for the first time without any provisions stating whether or not they would be forced to be slave or free should they be admitted as states. And again, both Utah and New Mexico, Utah is like half in, half out of the 3630 line. New Mexico is clearly below it. But the Compromise of 1850 basically said, hey, if they both want to come in as slaves, should they choose to, they can do that, or if they both want to come in as slave, they can do that too. It was the very first attempt at the implementation of popular sovereignty surrounding the issue of slavery within the territories. And the compromise also allowed California to enter the Union as a free state, which tipped the scale. So now when California comes in, there's more free states than slave states. But to get around that little hang up, and why this was a compromise, was not only the bits about Utah and New Mexico, but this compromise also included the Fugitive Slave Law of 1850. And the Fugitive Slave Law of 1850, I am going to talk more about, because this was one of the big ones. This was one of those pieces of legislation that folded a corner of the box. It was drafted by Senator James M. Mason of Virginia, who was a Democrat. It penalized any official who failed to arrest an alleged escaped slave a minimum of $1,000, which in today's money is roughly $37,000. It penalized any person who aided in an alleged escaped slave, or who aided an alleged escaped slave in any way. Food, shelter, didn't matter. It penalized them with up to 6 months in prison and a $1,000 fine. So again, $37,000 in today's money. 6 months jail time, $37,000 fine, just for giving somebody who might be an escaped slave food, or letting them sleep in your barn, or basically knowing they're there at all without turning them in. People could be arrested under the Fugitive Slave Law of 1850. People could be arrested on as little evidence as someone's sworn testimony that they were a slave. It made the writ of habeas corpus completely irrelevant when it came to the issue of if somebody is or isn't an escaped slave, because
the burden of proof is on the alleged person,
right, not on the person making the extraordinary claim. Trials under this Fugitive Slave Act were heard by a commissioner, no jury. Only the commissioner was permitted to hear cases. No accused escaped slave was permitted a trial by jury, indifferent of whether or not they were free citizens. Like I said, this Fugitive Slave Act, basically, if you were African American and free, this one piece of legislation said you are not a citizen of the United States. You are not protected by the Constitution of the United States, even if you're not technically a slave.
Yeah. And in practice, it essentially means that you're not free.
Yeah.
Because if your freedom can be taken away at any time for no reason, you're not really free.
Right. 100%. And it even goes even further. An accused escaped slave was not permitted to testify in their own defense at all. They had to remain silent. They were not allowed to speak in their own defense at these hearings. And commissioners...
I think that's the Fourth Amendment?
No, the Fifth Amendment is the...
is the right to remain silent.
Is the protection against self-incrimination.
Yeah, but I think isn't the right to testify that's in the Fourth Amendment under I just completely lost the phrase.
God damn it. I'm going to have to look. I'm legitimately not sure. We'll put a
due process. The due process clause.
Yeah. Okay. Yeah, that sounds about right.
Thank God it came to me.
the act goes even further. Commissioners who heard these proceedings were awarded $10 for each escaped slave they returned.
And let me guess, $0 for all the people that they found not to be slaves.
No. $5 for each accused that the commissioner deemed to have insufficient evidence proving they were an escaped slave. So either way, they got money, but you got twice as much money for returning an escaped slave as you did for not even finding somebody innocent of the charge, but just not finding sufficient evidence to say that they were an escaped slave.
Another way to think about that, and probably the way that commissioners did think about that, is you get $5 if they're a slave, and you get minus $5 if they're not.
Yeah, probably. So it should come as a surprise to literally nobody that because there was such a distinct lack of due process, the end result of this legislation was numerous free African Americans being kidnapped and sold into slavery in the South. And I actually think 12 Years a Slave takes place just a couple of years before this. 1847, 1848 is when that whole kerfuffle starts. And also, unsurprisingly, many in the North viewed this as the South forcing the North to become slave catchers due to the harsh penalties placed on any individual who failed to find or turn in an escaped, turn in, or not provide aid or help to an escaped slave.
Yeah, that's really kind of even an additional catch-22 that might not be immediately apparent to the listener is if it's a finable offense for you to give, I'll say, aid and comfort to an escaped slave, and it's also there's no burden of proof to determine that a particular individual is an escaped slave. That means there's no burden of proof regarding the aid and comfort. Mm-hmm. So you could give a loaf of bread to your neighbor, and then
who happens to be black,
and then is accused of being an escaped slave, or whatever the case. And because he gets no due process, you get no due process.
Correct. I'm sure when it came to white people accused of it, I'm sure there was a little bit of due process involved. Like, Mr. Harrison had no way of actually knowing that his neighbor was a fugitive slave. Mr. Harrison had only purchased this property 5 years ago. And when he purchased the property, this individual was already living on the property next door because this individual escaped their master, 10 years before that. So Mr. Right. Harrison had no way of knowing, he was, that he was providing aid and or comfort to an escaped slave. So I'm sure there was a little bit of that happening because white privilege.
Yeah. I do want to point out that, we use the term neighbor just because it's convenient. I recognize that white Americans were not likely to have literal black neighbors.
Very, very, very rare.
But, you could, I don't know if tipping was common, but you could tip a black waiter or, pay the shoe shine boy, right? Like if you're paying them for a service, like you are giving them money, right? So you could pay the shoe shine boy and
that could be seen as providing aid and comfort.
Yeah.
Yeah. So unsurprisingly, because of how
privileged,
because of how completely one-sided this legislation was, it went over like a lead balloon in the North. Even even amongst people who didn't really care one way or the other about the issue of slavery. The fact that this was clearly a piece of legislation that only benefited rich Southern slave owners didn't sit well with almost anybody in the North. And the last piece of legislation I'm going to talk about was a little bit of a follow-on to this, because there was so much backlash surrounding the Fugitive Slave Act of 1850, or the Fugitive Slave Law of 1850. As part of the compromise of the same year, we get Congressman Stephen A. Douglas. Some people might know that name. He was the opponent of Abraham Lincoln, very famously in the Lincoln-Douglas debates in the early 1850s, and for president in the election of 1860. So Stephen A. Douglas was a very prominent figure in American politics. He was a Democrat. He was from Illinois. He beat out Lincoln in the election of 1856 for a Senate, for Illinois, one of Illinois' Senate seats, I want to say. And the debates between Douglas and Lincoln are very historically significant. We're going to have an episode that they are covered in. But Douglas, suffice it to say, was a very prominent political figure. It's cool. Be cool. We're good. We're good. We're good.
For our audio listeners, the light is continuing to give me heart attacks.
So Stephen A. Douglas was the proponent of the Kansas-Nebraska Act of 1854. And what this did was it enabled the organization of the unorganized territories of the Louisiana Purchase into the territories of Kansas and Nebraska. And to gain Southern support for this bill, Douglas agreed to include a clause in the law that would allow for popular sovereignty to determine whether a state or territory was slaveholding. This, in effect, completely nullified the Compromise of 1820. That was now dead and gone. The Kansas-Nebraska Act replaced it with popular sovereignty. It was widely protested against by Whigs within the federal government, as well as by not only abolitionists in the North, but pro-containment people in the North as well, because there were a large number of people in the North who didn't care if slavery existed where it was. All they cared about was they didn't want it spreading. This very famously was Abraham Lincoln's public stance on the issue of slavery during the campaign of 1860, the presidential campaign.
We don't want to take it away. We just don't want additional states to...
Correct. Yeah, we're not saying you can't own slaves. All we're saying is you can't own slaves in places where it doesn't currently exist.
Nobody's saying you can't own a gun. We're not even saying you can't carry a gun. We're just saying you can't carry a gun in town.
If you recognize that quote, put it in the comments, or the doobly-doo for those of you who have been on the internet for 20 years.
Like and subscribe, 5 stars.
Oh, such a good movie. Anyway, yeah, that's basically exactly it. You know, there was a vast majority, a great number of people, I'll say, in the North who weren't abolitionists. They didn't care about that, but what they did care about was they didn't want the practice spreading to anywhere it didn't currently exist. And this not only pissed off the abolitionists, it pissed off the pro-containment people too. And this division even happened within the Whig Party itself. So there were many, many, many Whigs who said, this is bullshit. But there were some Whigs that said, okay, look, guys, it's really not that bad, you know? And this division between those two parts of the Whig Party ran so deep that this act killed the Whig Party as a political party. The anti-slavery faction, the anti-slavery pro-containment faction, went on to later, eventually, form the new Republican Party. And then the other faction that was kind of okay with this went on to basically just join the Democrats or found their own little political party with blackjack and hookers that went nowhere, and they ended up becoming Democrats or becoming Republicans anyway. Now,
that might have been the first Futurama reference on the show somehow.
It might have been.
You haven't said the name of the state, so.
There was something in here that I made a mental note to go back and just make a point of. So, one thing about the Compromise of 1850 that I had made a mental note to bring up at the very end of the spiel about it, but then I forgot, was I found a couple of accounts from later historians who said that the Compromise of 1850 forestalled a civil war. You know, it pushed back the likelihood, postponed it, basically. And at the risk of editorializing, which, I mean, I guess that is an editorial of its own, I'm not completely sold, because even though by the time we get to 1850, the sectionalism in the country was getting very near to a tipping point, I'm not convinced that the Compromise of 1850 was the straw that broke, or what was something that, if it didn't happen, would have been the straw that broke the camel's back and caused the country to fracture apart.
Yeah, even if it did delay the war by a handful of years, like, there's an argument to be made that it probably would have been better to have the war as early as possible, preferably before the proliferation of the mini ball.
Well, I mean, that started happening in like the 1840s, so yeah, that ship sailed long before any of this happened. But yeah. But yeah, I don't personally think that the way things were before the Compromise of 1850, I don't personally think a civil war was inevitable still. I still think there were avenues where, had this, that, or the other gone just a little bit differently, it might not have happened. But in either case, I don't know if the Compromise of 1850 actually postponed it, purely because I'm not convinced that it would have happened in the 1850s had it not been for the Compromise of 1850. I'm sure there's people that are going to disagree with me on that, and I actually would really like to hear those arguments for why this compromise, as broken as it was, did actually prevent the Civil War from kicking off in the 1850s. I'd like to hear those arguments, because for my own sake, I'm not personally convinced.
Yeah. Even if it did, though, it was by a maximum of 1 decade.
Yeah, maybe. Yeah. Well, literally.
If the Civil War had kicked off the instant that was shot down in Congress, that would have been a maximum of about 10 years.
No, yeah, you're right. You're right. But yeah, so, we see with these pieces of legislation, specifically, personally, I think everything after the compromise, or the Missouri Compromise, basically each of these pieces of legislation that I talked about, each of these were a side of the box folding up that furthered sectional division and brought us closer and closer to the point where civil war would be inevitable.
Have we directly addressed the box analogy?
I'm pretty sure.
Previous episodes?
I'm
I
pretty
feel like
sure we have, yeah.
I just want to make sure that we covered it in case anyone's going, what the fuck is the box? What? It's in the...
Aviation?
Yes, thank you. In the aviation community, there's a concept that aviation incidents are the consequence of a series of circumstances and decisions. So you can picture it as being a box that is folded in one side at a time by decisions and circumstances. So the circumstances, there's a thunderstorm. The decision is we're going to take off anyway, right? So each of these things that take place, they fold one side of the box. And at a certain point, you realize you're inside of a box that's folded around you, and it's too late. There's no way out.
Yeah. The incident can be avoided at any point until the box closes. Once the box closes, an incident is inevitable. And so I don't know if we ever explained it, but I know I've used the analogy several times at this point.
Yeah, I can't remember if I ever stopped you to explain it to the listening audience that aren't also aviation nerds.
Perhaps not, but yeah, suffice it to say, that's why I use that analogy, because, yes, each of these things folded up one side of the box, but at any point prior to the lid closing, civil war was not inevitable. And so if any of you have an argument for why the Compromise of 1850 actually postponed the Civil War from kicking off when it did, or postponed it from kicking off before it actually did, I would actually really like to hear those arguments. Legitimately, I'm not saying that to try and be smug or anything like that. I'm genuinely interested.
Yeah,
because it to my mind, it doesn't compute. I can't see a scenario. The closest thing I can see to that would be in the immediate wake of the Kansas-Nebraska Act, where all of that fighting happened along the Kansas-Missouri border immediately prior to the Civil War kicking off, where when Kansas was going to hold its election to determine if it was going to be slave or free, and pro-slave militias in Missouri crossed into Kansas to intimidate people into voting pro-slavery, and then anti-slavery militias came into Kansas to fight the pro-slavery militias, and it ended up being very medieval. That happened well after the Compromise of 1850. I think that was in 1854 or 1855, basically immediately in the wake of the Kansas-Nebraska Act passing. So I could have seen potentially the Civil War kicking off then, if Andrew Johnson, who was president at the time, had sent in the U.S. Army to stop the fighting. I could see that have kicking off the Civil War, but At least I think it was Andrew Johnson. The problem is you have two dudes with very similar names as president on either side of Lincoln. So it gets confusing. But suffice it to say, whoever the hell was the president at the time,
before Lincoln.
Yeah, or maybe immediately before that guy. Maybe it was Pierce. I don't remember off the top of my head. But suffice to say, whoever the hell was the president when this was happening, I'm fairly certain they were a Democrat and pro-Southern, which means they were just going to be like, oh, no, I'm not going to interfere in that, But if they had sent the U.S. Army in, I can see that kicking off the war prior to 1861.
Yeah, that could certainly escalate.
Yeah, I can see that happening, but 1850, I don't know. So, yeah, like I've said probably a million times at this point, if you guys have any arguments for why a historian saying the Compromise of 1850 postponed the Civil War by any length of time, I would really love to hear those arguments, because I just can't see it. But that's all I had to talk about for this episode.
All right, we got through it eventually.
We did. We got there. Go team. Go team go.
It's been trying.
We're not even done yet.
No. All right, everybody, I just wanted to say thank you for tuning in to the U.S. Civil War in excruciating detail. Again, I am Will. That is Steve. And Steve, in light of our having finished, I'm not aware of any announcements, so if you don't have any announcements to make, you want to hit us with the sign-off?
See it.
Hey everybody, welcome to the United States Civil War in...
Oh God.
What the actual fuck? That's going to the end of the show.
That is so going to the Oh God, it hurts. It hurts so bad.
All right, now I am going to have to go get paper towels.
What the fuck else, man?
Jesus Christ.